Okay. Ladies and gentlemen, I'd like to restart. But just before we begin this session is about the feedback from this morning. Before we begin, I think you should be aware that you seem to have caught the imagination of the social internet media world. The first session this morning was watched by thousands of viewers in 17 countries. There's been thousands of tweets from people commenting on what we said this morning and asking questions, which we'll feed back in the course of this session. And I do want to specifically thank our live tweeters here today at the back of the room. You're doing a fantastic job. Well done. Okay, we're going now to the feedback session, and we have coming up. This is what we'll be doing. The question: should Articles 41(2) be left as it is, modified, or deleted? And we have four slides to illustrate this, or to capture what was said this morning. The first two slides are dealing with leaving the article as it is, or deleting the article, and there are a relatively small number of comments in respect of each of these slides, but we'll go through them in a moment. And then the remaining two slides are ideas as to how Article 41(2) might be modified. So obviously, given that that's where the bulk of the opinion and discussion was, that's where the bulk of the time during this feedback session will be spent. But if we start with the first one, Article 41(2) as is, and just to be clear about what this means is that where a number is after a statement, that means that is attributed to that issue, that opinion was discussed at the particular table number. So, and the ones in red are the ones where there was quite a strong view at the table about this. So we're going to go through these first two slides relatively quickly, but I'm not going to, if you like, point and ask a particular table to comment, but I'd like people from any of these tables to volunteer, maybe to briefly comment on particularly the point that, well, table 11 obviously felt strongly that nobody at the table wanted to delete it. Does anyone from table 11 want to elaborate on that?
Hi. We said we were strongly in favour of keeping some form of it. We didn't want to delete it because it is the only thing in the Constitution that specifically values care, and we thought that care in all its forms was of great value to the community, and that it said something positive about us as a society, that we put a value on care.
So Deirdre, could you mention your name now?
Sorry, Deirdre Donaghy.
Yeah, and again, sorry. Thank you, Deirdre. And again, generally, if anyone stands up, please mention their name. Mary-Louise. We are, yeah.
The Table 12 never said that the article was harmless enough.
Okay. All right. Okay, well, that's a fairly substantial clarification. Table 13.
Hi, Michelle Colleen. Yeah, we never said that either at our table. The point we made is that there is a place for it in the Constitution. However, it needs to be rewritten. That obviously woman should be changed to person, not man or woman, just the word person. And that, basically, where is it? The common good, we had an issue with. We were like, well, what does that mean? Like, what way is that interpreted? And also the second part of it, that just basically it should be completely rewritten again. There's no point in changing a word or two. That should be completely brought back and redrafted. And we never said that someday it could be used. We're very confused about that at the table.
Okay, it seems to me we should move on from this slide and we'll go to the next one. Now, these are tables which said the article should be deleted. So, on any of these particular aspects, would anyone at any of these tables wish to speak, please? Yeah. Table 5 and Table 10 were the tables that appeared to have, if you like, the clearest view on these particular issues. For example, delete completely. Table 5 seemed to be the champions of complete deletion. Joan.
Joan Stewart, just where it says delete completely, what we actually wanted was to delete 41.22 only the second paragraph in it, and reword the first bit, but it wasn't to delete the whole lot.
Okay.
Thank you.
The view from Table 10 that thinking has changed from, I presume, from the 1930s, well, it's probably true, but would anyone like to elaborate on that view from Table 10? Having said, I wouldn't ask.
Maureen O'Sullivan. What we were looking at was the way in which it's not just in society today that it's the mother who predominantly does the caring in the home. We were looking at the role of grandparents and the role of extended family, the role of fathers. So in that sense, we were looking at the thinking has changed, that broad context.
Okay, that's a very helpful comment, I think, because it's a broader dimension of thinking has changed than some people might have thought. Yeah, table, I can't see which table.
Table 13.
13. Okay.
Susan O'Keefe. We thought really that the two articles probably needed to be deleted as they stood and rewritten. We felt it was a bit like a jigsaw puzzle, that there were pieces in there that we all agreed with. We agreed that it shouldn't be about women. We agreed it should be about people. We're not sure entirely if it might be about carers, just called carers, or whether it's people. We also thought that it might be within the family, or maybe not. Maybe it's wider. We didn't come to those conclusions. But we did feel that that whole concept of within the society and that caring role needs to be reflected in the Constitution, but not at all in the way that it's currently written. And so that was our recommendation, that we delete both of them, but rewrite something with those pieces of that jigsaw to reflect a modern 21st century Ireland.
Okay, thank you, Susan. Yeah.
PJ Murray is the name. We indeed had mixed views on 41.2, and particularly the usefulness of it. If we did already amend 41.1, we thought that the wording that the people from University College Dublin, the women's group, they had fairly good wording on 41.1. But if we adopted that wording, was there a need for 41.2 at all then? Because 41.2 is dependent on 41.1. And even in the wording of 41.1 that the people from Dublin, the women propose, we were concerned about the inclusion of the word of justice, and we thought we needed clarification as to what they might mean by of justice in that 41.1.
Thanks, PJ. I mean, just to be clear, or just to elaborate further, the people, the representatives of the UCD Women's Graduates Association will actually be on the panel tomorrow, so they'll be able to clarify that matter. I mean, just so that we're clear, I mean, we're here for the purpose of obviously capturing the feedback from this morning, but the comments that you're making are actually going to help us decide what we're going to put to you tomorrow as a vote. So I mean, it's a bit more than just listening to what happened this morning. It's actually helping to shape what you're going to vote on tomorrow. So just to put that in context. We might move on, I think, to the next slide, because this is where, if you like, the meat of the discussion appeared to be. And there's some how many? 7 bullet points here, and some clearly on a number of these issues, some fairly strong agreement at tables about some of these statements. So let's go down one by one. And I would encourage tables that haven't spoken up to now to speak. It should not be left as it is. Now, most of those tables haven't already. Well, I think 11 has spoken, but 3, 4, 7, and 8 I think haven't. Oh, 4 has. Yeah. If there's no takers, we'll move on to the next one. There are. Okay. I know that, yeah. Okay.
Sorry, Chairman, Jerry Buttermore. We just felt that in the first two that it was out of date, that it shouldn't be left the way it is, that the National Women's Council made a very good presentation and containing within their paper was a very strong wording which was gender neutral, which was an inclusive new modern Irish society which recognised the role of women and men and those who give care both in the home and in the community.
Thanks, Jerry. Any other comments about this first statement? We are going to have there are two slides about ideas about how to modify Article 41.2. Okay, let's move on then to the second one. It's out of date. Does Table 1 want to say anything about that? Or, well, Table 1 didn't feel so strongly about it. What about Table 2? Okay, we can't force it. Anyway, anyone else? Okay, maybe it's okay. We have a voice.
Kieran Egan, we just thought that it doesn't reflect the views of society today the same way as it did in the 1930s. So we thought that it was a useful article. It shouldn't be changed. It shouldn't be deleted, but it should be changed to reflect modern views. That's
okay.
all.
What about the next one then? Change just two words, women and mother. Now, Table 12, did you say this?
John Kenny. We were saying that in the first part of in 41.2.1 and in 41.2.2 that it's listed as woman in the first part and mother in the second part, and whether there'd be the need to be consistent across the two articles if it was to be modified, or if there was some reason for having woman in the first part and mother in the second part as it was. So that's the way we were looking at it.
Okay, thank you, John. The next one is one which obviously, again, a lot of tables felt strongly about, that the article should be gender neutral. So who wishes to speak to that? I'm going to take maybe 3 contributions on that, given the importance of or centrality of this issue. Yeah.
Hi, Brona Farrell here. We were saying that at this stage, to reflect the modern society, that caring in the home is no longer just a female role, and that if the wording took that out of it and made caring more of a broader aspect, but also that there would be structures put in place to define what the caring side of the role is, and that it's not just a woman's role.
Mm-hmm. Okay, thanks, Brona. Yeah.
Hi, Alan Green here. I just want to agree with the last speaker there. At this table, we felt very strongly that the wording must be gender neutral. Roles have changed, and the father now does play a much greater part in family life, in home life. And that any wording should not just be gender neutral to allow inclusion of both parents, but also to include the broader definition of carers as well.
Okay, thanks, Alan. One more comment on this particular issue of the article should be gender neutral? Yeah.
Thank you. Catherine Murray. When I came in here this morning first, my first impressions was that it should be gender neutral. But having listened to all the discussions around this table, and particularly to the lady Regina here beside me, I thought she made a very valid point about the contribution of the mother in particular in the role of the family. And having listened to that, I now feel that the contribution of the mother should be mentioned specifically in the Constitution. But to add to that the contribution of other carers, be it the father or grandmother or whatever, that we don't, we can't afford to lose sight of the contribution of the mother, even in carrying the children, rearing them, and everything that a mother does. So I have changed my view on the gender neutral after that.
Okay, thanks, Catherine. Thank you. Could we move on to the next item, the next comment here? The wording of common good needs rephrasing. Now, I know there was a comment very early on from Michelle about something along these lines. I'm not sure whether it's exactly the same point that's being made or not. Yeah, Susan. Mike, yeah.
Thank you. We had a kick around of what the expression common good meant, and in fact we did ask Siobhan for a legal interpretation, because the way that it is phrased we thought was a huge sort of burden that woman gives us. The state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. It seemed like an enormous thing to be saying, that common good couldn't be achieved without the life of the woman within the home. So we were at that point still talking about how we would change or how we would rewrite. So we're not necessarily saying that it needs to be rephrased. We're querying it as an expression and wondering, when we finally concluded we would rewrite the whole thing, in fact. We weren't sure then where the expression common good would or would not be in there. But that's how it arose in the first instance, that we looked at rephrasing it at all, was that in the way that it's written, it appears to put an enormous burden on the woman, which we thought was a bit peculiar.
Okay. We're very glad we still have Gerard and Siobhan with... Oh, Gerard is here, I think. Anyway, yeah. And maybe at the end of this full round, we might ask them to make a comment on some of the comments that they've heard. Next item needs clearer definition of marriage, families, endeavour, mother and duties. Okay. I don't think Table 9 has spoken thus far, so maybe would it be appropriate to Table 9 to speak, please?
Mark Daly. At our table we had an interesting discussion with Professor White, and where he explained that under the Constitution the family is very narrowly defined as a married couple, and therefore separated, divorced or single parents are not covered by this provision, and that's why we wanted a change to a broader definition of the family, so that it would include, the family would include single parents and other non-married people.
Okay, thanks, Mark. I mean, that, okay.
Hi, Deirdre Donaghy. We were talked about the issue of endeavour and the bit that where it says the state shall endeavour to ensure. And some people originally had the thought that, okay, we should just change that, the state should ensure. But the difficulty with that was, we thought, do you then end up with the state ensuring that a gender neutral person can stay at home? Does that mean they can both stay at home? Does that mean nobody ever has to work? We thought possibly we might run out of money.
Okay. All right, thanks, Deirdre. Comment here, table 3, I think.
My name is Yvonne Carney, and on this I think everything has changed so much. The mother will always be the top in the family, but from childhood, why is that funny? They've carried the child and they're reared for so long, but then they go to play school from infants, then they're in school. The mother is out in a full-time job, and half the time the children go back to a grandmother or a neighbour or somebody like that. So I think marriage is on its way out, because partnerships are all the thing now. And then families are very, very different from what they were 50, 40 years ago. Like, the woman isn't there in the house all the time. She's out and she's using her brain. We discovered we had one. and we weren't dependent then on the husband. But there's a whole different thing going on now, and especially with the foreign families. They've different ways, and they influence, and we influence them. So I really think that it just needs a clean out, and everybody accept their own lives. Okay?
Thanks, Yvonne. Table 5, please. Yeah.
Thanks, Chairman. Tom Burke. We understand that a single parent and a child would not be classed as a family under the current interpretation. Likewise, an older sibling looking after a younger child would not be classed as a family. Without going into any other combinations, there are those, and we suggested an amendment to the wording of 41.1 to read, "The state recognises persons living together as a family unit as the natural, primary and fundamental unit of society." And we feel that's all-embracing, covers every possible combination, and it allows the people in the household to decide themselves whether or not they want to be classed as a family. Thank you.
Thanks, Tom. We'll certainly go back to Jerry White for a comment on this at the end, but table 10.
Aideen Larkin, we just wanted to highlight, we agreed with Table 9 on the whole definition of family, but we felt it maybe is a bigger issue. It isn't something that we need to, we could bring up in terms of voting for tomorrow. It could be something, because the family is such a hotly debated topic, I think, if you like, at the minute. The definition, it does require, I think it's going to need to be revisited possibly in the next convention we're discussing as well. So maybe it is something that we felt at the table it could be considered for any other business weekend. It is a hugely interesting topic, I think, that does need to be considered.
Yeah. There may indeed be issues that we may not attempt to definitively determine or take a position on at this meeting, because, as you say, Aileen, there are other sessions later down the tracks which are already programmed, which may have relevance to some of the things we're talking about on this occasion. Anyone else want to, because, okay, table 13 again.
Elizabeth Clarnon, we just wanted to note that in Article 41 it just says the home, it doesn't say anything about family, and we made the point that family doesn't necessarily mean home, and home doesn't necessarily mean family. Yeah.
All right. Okay, I want to keep moving on, because we've one more full slide here, and there is the last point on this table was protect rights to share in the family home. Table 9, anyone from Table 9 want to comment on that?
Thank you. Mary Mitchell O'Connor. I think what we see in Section 2.1 and 2.2 is that women in the home and women that go out to work, I think sometimes the woman that goes out to work, her role can be lessened, and especially then when you're going through the family courts, because in the family courts, if you are working, you know, a family home will be divided, whereas if you're a mother in the home or a person in the home, you may be allowed to stay until your children are 18 and 20 or 22, 23 while they're in full-time education. And I suppose that's what we just would like to kind of bring this point up and see a comment maybe from the expert group there, please.
Thanks, Mary. We'll move on to the last slide then, and maybe we'll take a number of comments here. I'm going to leave this entirely open, so anyone who wants to comment on anything that's up here, we'll take those comments. But I do want a bit of time left, certainly maybe 10 minutes left at the end of our session. We've 20 minutes left altogether in this session. Maybe 10 of those minutes I'd like to have the chance to have Siobhan and Jerry back up here to comment. So this slide, who wants to talk to anything on this slide? Derek. Here.
Derek Keating. Thanks, Chair. I just want to mention one point that occurred to me that I shared with the table. I think there was some support for it. In relation to the final line or two I'm referring to 41.2.2, where it says, the necessity to engage in labour to the neglect of their duties in the home. I just felt there's a very negative connotation there. And I suppose that occurred to me because I spent 3.5 of the most rewarding years of my life as a parent in the home a number of years ago. And I really do feel that in considering this article of the Constitution, we have an opportunity to not only take on board some of the suggestions, and we shared on them there, the gender issue and so on, and the carer, but also that negative connotation. And I think, there's a privilege associated with it. And I think we have an opportunity to increase the profile of it and the standing of it by looking at that negativeness that comes out there, by maybe including, and I haven't come up with the sort of the perfect solution yet, but endeavouring to support the carers financially in their important contribution. It is a very significant contribution, not only whether we consider it in the context of the home or the community at large, but it is a very important contribution, and I think we have an opportunity to do that, to improve its standing, if you like, and give it that positive connotation in considering this review. Thank you.
Thanks, Eric. Any other comment from this slide? Stephen.
Stephen Agnew, and I'll try and adequately reflect the discussion at our table rather than just my own personal views. But on the last point where we discussed paid and non-paid, I'm not sure we said that they should not be differentiated, though that was certainly the views of some. But it was just a question of open up. If we move care to community, then do we start talking about childminders? And whilst not trying to say that it's in any way a less valuable role, but it's the differentiate about how we see within the home or within the family, a child parent caring for a parent or a parent caring for a child, the difference between that and a professional role. Maybe paid and non-paid is the wrong rule, but the difference between professional role and non-professional roles, I think maybe is the better. But I don't think we came to any solid conclusions, but it was again something need to be considered in the context of the wording.
Thanks, Stephen. Table 5, Ivana.
Ivana Bacik, Table 5. Just to say on that first point that we also thought that the article should be modified to be inclusive of all caring roles, so that we would include or the community as well as within the home. And we thought that was a good way of accommodating what the National Women's Council had suggested. And in addition, as Joan and Tom have said, we also thought that the article as a whole should be made more inclusive, so that the reference to family as being founded exclusively on marriage should be removed. And we should call the article Family in the Community, because it's really about the human relationships between family members, between those who define themselves as being part of a family, so that we would be inclusive of caring roles generally, of persons who care for others, and of different forms of family and more diverse forms of family.
Thanks, Ivana. Yeah, Table 7, please.
Owen Finnegan. I'd just like to reiterate what table number 1 said about the positive role of the mother. Our table, while we agreed that it should be gender neutral, there should be also a reference to, I suppose, the natural maternal instinct of the mother, and that should be reflected in the wording of the change.
Thanks, Owen. Table 1, please.
Hiya, Ciara Conway. I suppose maybe my opinion differed from everybody else's on the table, so I just feel I should maybe add that into the mix. I actually, and it's something I don't think we've heard a lot of people talking about, I favour the abolition of it, of any reference in relation to it. What we really should be looking at is Article 41.3 in terms of the definition of the family, and then that allows us to look at how we think of, in a modern day society, what constitutes a family, because currently as it stands, it does stand to preclude a lot of what is a modern day family, and the implications that has for the children of those families, but also for the kinds of policy that is formulated, that it is very much towards the biases towards, particularly in relation to health and in relation to social welfare matters, the biases towards the married breadwinner family. So my position very clearly is that we should abolish it, and we should reform Article 41.3 in relation to the family.
Okay, thanks, Ciara. It's actually an important principle here that, even if there is a majority at a table, there will be other views as well, and we need to make sure we capture some of those as well. Tom.
On the same point, Mr. Chairman, minority of one, I'm afraid, but I feel that there's a conflict between between 3.1 and the rest of that article. 3.1 says the state pledges to guard with special care the institution of marriage, and the rest of the article goes on to provide for divorce. I think we could delete both of them. We're not we're not doing away with divorce. We're not necessarily attacking marriage, but at the moment I find them meaningless and in conflict with one another. Thank you.
Thanks, Tom. I think Mary Lou. Yeah.
Thank you, Mary Lou MacDonald, Table 3. We raised the issue of the term endeavour and the need to change that from sort of a fairly wishy-washy aspiration into an imperative for the state. Our discussion, I suppose, like lots of other tables, we talked about that notion of giving a legal clarity and visibility to the value of care and all those who provide it, but also differentiating then, I suppose, a very particular parent-child, for instance, relationship in respect of that caring role. And we also came down in the discussion in favour of the concept of home appearing in the Constitution. And homes, as we know, could be, as Yvonne was saying, a one room or a mansion or a caravan or wherever you call that place. But in the balance of the Constitution to reform the article to make it clear that caring is not a gendered activity, and also recognising the value of it. At the end of the day, children don't rear themselves, and at some stage each and every one of us will be dependent on that. So it's about giving constitutional life to that function in society and making it an imperative, not an aspiration.
Okay, thanks, Mary Lou. I really would like now if I could invite Jerry and Siobhan. It might be simpler if you come up here so that people can actually see you. Because we've had I think quite a rich discussion with quite a number of diverse comments, and I think there may be some general threads or points that at least both of them felt came through, or the points that maybe of particular importance out of that discussion, which they would like to comment upon. And whichever order you wish to, well, you're sitting down first, Siobhan, so, or would you make it up between yourselves, decide among yourselves?
No, I'll be very brief. On the question around the use of the term endeavour, that raises the question of what kind of obligation you want to impose on the state. Is it an obligation to endeavour, or is it an obligation to ensure that caring roles are supported? So it's what kind of obligation that raises that question, and to do what exactly, to care for dependents or for parents to care, or care within the wider community or society or in the home. So it's the nature of the obligation that could change if you move from endeavour to ensure, and that imposes a different kind of obligation on the state. And we also touched on the point this morning that even if you do that, you then need to raise the question, are you also going to say that that can be enforced by the courts and has to be enforced by the courts, and what does that mean? Certainly on the way it's phrased at the moment, as you noted, it's about it makes this reference to neglecting duties within the home, which does seem to have a negative connotation with regard to those who might work outside of the home. And again, it's gender specific.
I mean, could I maybe just intervene here, because my work over the last 11 years with Concern, I'm familiar with a lot of different countries, and some of them have very fine words in their constitution which really have no practical meaning because the state has no capacity to influence this. And when we get to the issue of endeavour or a stronger version, isn't there going to have to be some connection with the consequences of if something is judiciable, as they call it? Doesn't that bring with it also an issue of resource connection?
Yes, it does. And where you do have an obligation of result, if you like shall ensure, rather than shall endeavour, which could be seen, are you taking steps? A stronger obligation can be limited if the state does not have resources, but what might happen then, for example, is that there's a check on, well, how are you allocating what resources you do have? So are you making the choices? Is the state making choices that comply with the obligations that are imposed by the Constitution, or is it allocating resources to one sector at the expense of the other? So within the state's capacity to the maximum of its available resources, that's what international human rights standards would say, for example, what kinds of choices are being made around the allocation of resources, and are those in compliance with the values that are enshrined in the Constitution? Because they may not be. So, but it is within those constraints. Yeah.
Okay.
Obviously.
Okay. So, Jerry.
Thank you, Chair. I suppose I just briefly address 2.5 points. First point was just one of the tables wanted to know something about the common good and perhaps how that is understood in the Constitution. And I suppose generally the common good, as we'd all understand it, is the general welfare of society. There are 4 specific references made to the common good in the Constitution. In the preamble, we're told that one of the objects of the Constitution is to promote the common good. In Article 43, we're told that the rights of private property can be regulated in the interests of the exigencies of the common good. Similarly, in relation to freedom of expression, in Article 40, Section 6, subsection 1, the state asserts the right to regulate freedom of expression in the interest of the common good so that public order and morality are not undermined, or that the authority of the state is not undermined. And then finally in Article 42, Section 4, we're told that it's an aspect of the common good that the state has a duty to provide for free primary education. So you can see how in different contexts the common good can require a very specific outcome. In the context of this clause, there was an acknowledgement in the existing clause that woman providing support in the home is advancing or contributing to the common good. I don't know if I can say much more about that. In relation to the sense, or the question of the family, just to clarify what the constitutional position here. Article 41.2 obviously is located in Article 41, and Articles 41 and 42 have been interpreted by the courts as applying only to marital families, families based on marriage. That would include, a marital family with children. It would include a childless couple. It would also include, in my opinion, siblings, say orphan siblings, where the parents are dead or where one parent is dead. So that's the marital family. With regard to non-marital families, the unmarried mother and her child or children, they are constitutionally protected by another clause in the Constitution, Article 40, Section 3. And the constitutional rights of the non-marital child are equivalent to the constitutional rights of the marital child. Penultimately, you've got the unmarried father who doesn't have constitutional rights. Insofar as the Constitution will protect his interests, it's only insofar as that would be protecting the interests of the child. So if the natural father had a long-term relationship with his child or children, the courts would move to protect that relationship, but they're coming at it from the perspective of what's in the best interest of the child, not saying that the natural father, by virtue of being a natural father, has constitutional rights. And then, of course, there's the other question of, so far I've been talking about heterosexual couples, then there's the question of the position of same-sex couples. There is an academic debate here as to whether the existing text could be interpreted to cover same-sex couples as the text is at the moment. My view is probably not. So I would take the view that the Constitution currently applies only to heterosexual couples in these clauses. The half point was just in relation to add to what Siobhan had said in relation to socioeconomic rights, just to note that the South African Constitution has explicitly, in 1996, has explicitly protected certain socioeconomic rights, and the South African Constitutional Court has taken the view that this gives the courts the power to review decisions as to whether they are reasonable, whether having regard to all the circumstances, the state has done enough to provide for housing or healthcare or whatever, clean water. So it leaves a reasonable amount of discretion still with the political system to decide how to allocate resources.
Okay, thank you. That's very helpful. David, did you want to comment?
My name is David Cullinan. I thought that the presentation from the National Women's Council was actually very good, because the three broad principles that underpinned their presentation, and I suppose their argument to modify the article, was that it would be gender neutral in terms of the recognition of work both by men and women, that it would recognise work, and it mentions in the home. So the home is still mentioned, but it broadens it out to include in families and in communities. But also a more positive interpretation of caring as well, that's in the existing article. And I don't think it in any way takes away from the role of women in relation to caring. I don't think it's taking away. I think it adds value, that it recognises that, well, men have a role to play as well, so it's about equality and equal recognition. But there was many issues that came up as well that go beyond just what was being discussed. Some of them were policy issues, some of them would be a matter for government in terms of resources, but some were about rights as well. And I think it would be maybe an opportunity for us at some later point, and we have the open remit session, to look at the possibility of a bill or a charter of rights that would look at gender inequalities, social and economic rights, and maybe, because it's some of the issues that came up, I think, were something that would be best suited to that sort of model. And maybe as we, get to have discussions about what should be in the open remit, I would think that concept of a bill or a charter of rights would be one that we could potentially look at.
Okay. David, I think that's going to be the last word on matters on this particular session. I want to thank everybody. It's been I think a very rich discussion. I think it raises really interesting challenges as to how we're going to reflect that in the questions that we will put back to you tomorrow morning.